Right, it's 1 o'clock and I can see people are joining. So welcome everyone. Good afternoon and thanks for joining. Welcome to this Francis Taylor Building Public Law webinar. And the topic today is the practice and procedure of judicial review. Just to introduce myself, my name is Flora Curtis. I'm a barrister at Francis Taylor Building and a member of the Public Law Practice Group, and I will be chairing this seminar today. Just for Zoom admin, if you have any questions during the seminar, please ask them using the Q&A function, which I'm sure you will all be familiar with by now. Our speakers will endeavour to answer as many of your questions as possible at the end of the 3 talks, but we will be stopping at 2 o'clock. So if you have any questions that haven't been answered, feel free to email those through to me or one of the speakers, and we'll try to make sure they're answered. Just to also let you know, we're recording this webinar and it may be published on the FTB YouTube channel. So the topic of today's seminar is the practice and procedure of judicial review. Our speakers will be giving an overview of those 3 topics, 3 topics that fall under that broad umbrella: alternative remedies and judicial review, standing and expert evidence, as well as giving an update on recent important case law. And we have 3 speakers from FTB today. Our first speaker is Horatio Waller, who was called to the bar in 2014 and has a wide range of public law and judicial review experience, for example, in the areas of education, police law, equality law, religious liberty, information law, licensing, planning, and local government. Horatio acts for both public authorities and individuals and was appointed to the Attorney General's C panel of counsel at the earliest opportunity. Horatio will be discussing today 3 recent cases that deal with judicial review and the existence of alternative remedies. So with that, I will hand over to Horatio.
Thank you, Flora. Good afternoon, everyone. Lovely to have you joining us for this webinar. Let's start by sharing my screen. Good. As Flora has mentioned, I'm going to be speaking about alternative remedies. Context: at the permission stage for judicial review, only exceptionally will you get permission where there is an adequate alternative remedy. Most authoritative statement of that principle is the Wandsworth County Court case and Lord Phillips within it. I'm going to talk about 2 recent planning cases that demonstrate the breadth of that principle. And then I'm going to talk about the converse scenario, which is where a complaint is made to the local government ombudsman, and in that context, judicial review itself can be considered an alternative remedy, such that you should not be allowed to complain to the LGO, the local government ombudsman. I was involved in the IBRA case and the Piffs Elm case, and it was Brendan actually who's involved in the Blot Media UK Limited case and who very kindly told me about it so I could talk to you about it. So a bit of background. For the planners here, this will all be very familiar territory for you, but if you're not a planner, section 289 of the Town and Country Planning Act is a provision that creates a sort of set appeal procedure for appealing the decision of the Secretary of State following an appeal against an enforcement notice. Appeal against the enforcement notice is conducted under the grounds set out in 174 of that same act. The appeal under 289 is also to the High Court, and as I'll expand in a moment, the grounds that you can bring such an appeal are quite similar to judicial review. Where there is a real difference, though, is that the 289 procedure is subject to a 28-day time limit, which is stricter than the 6-week time limit that applies for a planning JR. So the IBRA case, by way of background, you had 2 applications for judicial review of decisions by planning inspectors after the 28-day time limit that would apply for a 289 appeal, but they were within, or just in one case, just shortly after the 6-week period for judicial review. what had happened in both those cases is that enforcement notices under the Planning Act had been served against development. There have been appeals against those enforcement notices under 174 of the Act, and the appeals have been dismissed. The two applications were joined for determination by a single judge, ended up being Mr. Justice Eyre, because they raised similar procedural issues, but factually, the two cases were distinct. In terms of the issues, the first issue was about the effect of Section 285 of the same Act, which I've set out for you there. It says the validity of an enforcement notice shall not, except by way of an appeal under Part 7, that's the 174 appeal route I've mentioned previously, be questioned in any proceedings whatsoever on any of the grounds on which such an appeal may be brought. It was common ground before Mr. Justice Eyre that 285 doesn't preclude an application for judicial review of an inspector's decision letter upholding a notice. So in other words, what 285 is an ouster of judicial review where the challenge is directly to the notice itself, but it is not an ouster to a challenge of an inspector's decision letter that considers an enforcement notice. So the Secretary of State, who I was for, our position was a bit more nuanced than that permission should be refused for judicial review because an appeal under 289 would have been an adequate alternative remedy. And the claimants responded to that submission by saying 289 is not an adequate remedy for their claims. But if that's wrong, then they should get permission to substitute their claims for a 289. And I should explain by way of context that it was apparent by the time that the hearing took place that the argument that 289 is not an adequate alternative remedy had been thought up really as a way of justifying the routes that had been taken. And at the outset, the different lawyers who were involved hadn't really appreciated that 289 existed as the route of challenge for this type of decision. So that's why the argument took the route it did. So the first thing the judge considered was, is 289 an adequate alternative remedy for judicial, for a challenge to a inspector decision letter rather than judicial review? And the judge said this, that normally it will be an adequate alternative remedy and exceptions will be vanishingly rare, as you'd expect, because this is a route that's been created specifically to challenge inspector decision letters. So that's not especially surprising. Then next point, important point, the existence of an adequate alternative remedy and its adequacy are determined at the date of the decision under challenge. So in other words, what you can't do is wait for the 28-day time period for a 289 challenge to lapse and then say, I no longer have that as a remedy, so you should grant me permission for judicial review. That doesn't wash, because at the time of the decision, you could have gone through the 289 procedure. Judge also said the scope for challenges amenable to a 289 appeal is similar to that amenable to judicial review, as I mentioned earlier, subject to a possible limited category of mistake of fact that can be pleaded only within judicial review. So just by way of context there, the advocate for one of the claimants had gone into a lot of detailed research to form the proposition that there is this very limited category of mistake of fact that you can only plead in judicial review. And the judge wasn't wholly convinced by that, but thought it was possible. But as I go on to say in the next bullet, that the judge found that all the areas of law pleaded in these cases were plainly alleging areas of law, and you could bring those under 289. And for that reason, 289 was an adequate alternative remedy. And the judge also went on to point out that even if the ground of challenge was one that's only amenable to judicial review because it's a type of mistake of fact, it's questionable whether it would be appropriate to grant permission for judicial review in those circumstances where Parliament has created a bespoke procedure for this type of challenge where that ground cannot be taken. So it's quite an interesting point, and that's one that might be considered again in a future case. Then if 289 is an adequate alternative remedy, the judge said that the cases where it's be appropriate for JR to proceed will be vanishingly rare. Same phrase used again. And whereas in these cases, by allowing JR to proceed, you'd be subverting the stricter 28-day time limit. That's a point of significance against granting permission. Then there was the final issue, which was, well, should the claimants be allowed to substitute their claim for a 289 claim? And that was their sort of backstop argument that both advocates took for the claimants. And the judge said that there's a spectrum of cases that could arise. At one end of the spectrum, the JR applications made within the 28-day time limit, the time limit that applies to the proper procedure. And when the issue is raised, the claimant is content to proceed by way of 289. And in those circumstances, permission should generally be granted. Then in sort of the middle of the spectrum, the application is filed beyond the 28 days, then you consider the Denton and White test. So this is the test for relief from sanctions that applies where CPR rules are not respected. And so the Denton and White test, you consider three factors: the seriousness of the breach, the explanation, and all the circumstances. And the judge said that even if it's a small delay, that could still be fatal against this application. Then at the end of the spectrum, you have a case like the one before Mr. Justice Eyre for both claimants, where the claimants had persisted in seeking to proceed by judicial review, not swapping for 289. That weighed against the application because it had meant that court time and resources were wasted in determining and rejecting that primary position. So by way of summary, use judicial review, do not use judicial review to challenge an inspector's decision letter on a 174 appeal. Use the 289 procedure. But if judicial review is lodged against that decision, it is appropriate to then substitute the claim for a 289. And it's likely that application will be granted as long as the claim was lodged within the 28-day time limit. And what this case is clear on is that you can't use judicial review as a last-ditch attempt to challenge an inspector's decision letter after the 28-day time limit that applies to a 289 appeal. Next case, Blot Media. The context is somewhat similar. You've got another unsuccessful appeal against enforcement notice and then an attempt to bring judicial review. The enforcement notice required the dismantling of an advertisement board on a building. The owner of the building, called Solar, submitted an appeal under grounds D and E of the Act. The planners will know what that means, but those who are not planners, ground E is you're saying that the notice has not been served on someone it should have been served upon, i.e., in this case, the owner of the advertisement board, which is the claimant to the litigation. Now, the claimant, the owner of the advertisement board, didn't appeal the enforcement notice. The enforcement notice got held, and the inspector found that the claimant wasn't required to be served with the notice. A ground D appeal is about the length of time that the development that the notice is concerned with, the length of time that it's been present, and the inspector found that that ground could be dismissed because the development had existed for less than 4 years. So what were the issues in the High Court proceedings? These issues arose at the commission stage. The claimant had sought to challenge the findings made by the inspector on the ground D, i.e. the finding of how long the development's been going on for. And the High Court needed to consider two issues about the adequate alternative remedy. First is, even though the claimant wasn't party to the appeal against the notice, could the claimant have appealed the decision of the inspector to the High Court under 289? Secondly, if it couldn't, could the claimant have appealed the notice in the first place? under 174 of the Act in order to run its own case. On issue 1, the judge, Timothy Mould-Casey, sitting as a deputy, he indicated that he felt probably the claimant had an interest in the land to which the notice related for the purposes of 289, such that they could have brought an appeal under 289. However, it's important that the inspector had determined the converse, which is that the claimant did not have an interest when the inspector reached the decision that the ground E appeal should be dismissed, i.e. that the claimant wasn't required to be served with the notice. So the judge appreciated the tension there, and for that reason decided not to refuse permission on that issue. So the judge went on to consider issue 2 and found that the claimant is, for the purposes of section 174, which creates the right to appeal against enforcement notice, so the claimant is a relevant occupier of the land and therefore has a right to appeal. And although the notice wasn't served on the claimant, it clearly was aware of it as a witness statement or a document signed by the claimant who had actually appeared before the inspector in the appeal. So clearly the claimant knew the appeal was ongoing. So for that reason, the judge said that the claimant had an opportunity to avail itself of the 174 procedure to challenge the notice. It hadn't done so. And in a section 174 appeal, the claimant could have made its arguments about the length of time that the advertisement board has been present. And then if it had lost the appeal, the claimant could have then appealed that decision from the inspector to the High Court under 289. So therefore, there was an adequate alternative remedy and permission was refused. So by way of summary, if you have an interest in property affected by an enforcement notice, you've got a right to appeal the inspector's decision notice to uphold the notice under 289, even if you weren't served with a notice, and even if you didn't appeal the notice, you can still go to the High Court in under 289. But also, if you have an interest in the property or you're a relevant occupier of it, you have a right to appeal the notice under 174 to a planning inspector. And an application for judicial review of an enforcement notice will be refused where these alternative remedies are not taken by the applicant. So finally, the Piffs Elm case. So as I mentioned, this is a different context. This is the converse where someone wants to complain to the local government ombudsman and it's said that they could and should have gone to judicial review. Very sort of lengthy factual background to understand the full decision, but for our purposes, I can give you this sort of potted summary, which is that complaints were made by a company, Piffs Elm Limited, about the handling of a planning application by Tewkesbury. The complaints were about a decision to decline to determine a planning application. So the planners will know that there's a power under the Act to decline to determine applications under certain circumstances. And then after that decision had been made, the council refused to repay the planning fee, which was substantial in this case. It was about £40,000. The ombudsman initially issue a final report upholding the complaint. So they say the complaint is well-founded. But then subsequently it purported to withdraw that report and issue a further report dismissing the complaint. There were then judicial review applications against the reports by both Piffs Elm and by the council, and the court considered lots of different interesting public law issues. Do read the judgment, it's a good read, but only one is relevant for my purposes. And it's this point that the ombudsman argued before the court that upon reflection, in retrospect, it lacked jurisdiction to even consider the complaint. So its first report upholding the complaint must be legally flawed. And it argued that the complaint was premised upon a contentious legal proposition. The proposition was this, that local planning authorities have a general discretion to refund planning fees, and that's appropriate for judicial review and determination by a judge. It's not appropriate for the ombudsman. And the bit of law in the Local Government Act 1974 that creates the regime for the local government ombudsman So I set that out, it's 26.6, and it says that the LGO shall not conduct an investigation in respect of, amongst other things, an action in respect of which the person affected has or had a remedy by way of proceedings in any course of law. But then there's a discretion to conduct an investigation if satisfied that in particular circumstances it's not reasonable to expect the person affected to resort to it. The Court of Appeal upheld the Ombudsman's argument on this issue, found that that provision I've just read out applies throughout the Ombudsman's investigation because it's fundamental to their jurisdiction. So therefore, if at any point it becomes clear, even at the stage where pen is being put to paper for a final report, it becomes clear that there's an alternative remedy and that it was not or would not be unreasonable for the complainant to resort to it, the Ombudsman has to decline jurisdiction. And the Ombudsman should have, in this case, determined it had no jurisdiction to investigate the complaints because these were pure points of law and it was reasonable for PIF's Elm to go to judicial review. So overview, in that case, the complaints were premised upon an issue of law. That's, of course, not always the case with complaints to the Ombudsman, but in that case it was. And in those circumstances, judicial review was an appropriate remedy. Whether it's reasonable to resort to judicial review will, of course, depend upon the facts. One fact might be the resources of the complainant. The judgment could have serious implications, but do note that there could be an application for permission to appeal to the Supreme Court. And I note a practical implication, which is that you as a complainant or claimant will have to at an early stage decide, do you complain to the Ombudsman or do you seek judicial review because of the strict time limit for judicial review? And what would be tactically unwise, if there's any doubt, is waiting for the Ombudsman to make a decision on this jurisdictional issue, because by the time you've got a decision from the Ombudsman, the time limit for JR will have certainly expired because the Ombudsman doesn't turn around reports quickly. So thank you very much. That was all I wish to say.
Thanks very much, Horatio. And it's an important reminder of the fine balance between pursuing alternative routes of appeal where appropriate, but also not missing the boat on bringing a judicial review claim where that's what should be done. Just a reminder to anyone who's attending to put any questions for Horatio in the Q&A box. So moving on to our next speaker is Kate Olley. Kate was called to the bar in 1999 and has considerable experience acting for both claimants and defendants in a wide range of public law matters. She regularly appears in the High Court and the Court of Appeal and has acted as sole counsel in the Supreme Court. Kate is also DV cleared and has conducted extensive exculpatory reviews in the context of appeals to the Special Immigration Appeals Commission. Unfortunately, you may have noticed that Kate isn't here today. She's in an inquiry and her lunch break hasn't aligned with this seminar, but she has pre-recorded her talk on standing for us. So I'm going to attempt to share both her slides and the audio at the same time, which is testing my technological ability, but I'm sure one of the other speakers will frantically wave at me if something goes wrong. So I will just try and do that now.
Good afternoon. My talk is about standing. I apologise not to be there to do the talk live, but I hope this recording will help, and please do feel free to direct any questions to me through Chambers. The first slide then. So standing is all about who. Does the claimant have a sufficient interest in the matter to which the application relates? And just to do a quick rundown of the basics of this issue, it's jurisdictional. It can't be something that just to be agreed away between the parties. It is something that the courts give a flexible interpretation to, so the claimant's relatively unlikely to be knocked out at permission stage. The issue can still be relevant at the substantive stage anyway, because it may go to relief, or it may not even be decided until the substantive stage, because the court may need to look at the factual and legal elements of the case before the answer on standing becomes clear. We see that, for example, in the Zamran Zafar case, which was a planning enforcement decision. The court said, without looking at the nature of the complaint, one cannot know whether the claimant could have a sufficient interest. It's also well established that a claimant can be a surrogate. For example, Lord Carnworth in the Edwards case said, following Attorney General Cocotte, the environment cannot defend itself. It needs to be represented by concerned citizens or organisations acting in the public interest. Environmental groups then are obvious examples of cases in which claimants will have standing because the case is a public interest matter. Possibly in planning decisions, although it might be harder to establish if someone perhaps is going to have an adverse view of a development in question, but certainly can be the case in planning decisions as well. And there may be suitably expert organisations much better placed to present arguments about the impact of policy on the affected class as a whole, rather than one individual in particular. So, for example, a Child Poverty Action Group, Joint Council for the Welfare of Immigrants, the Howard League for Penal Reform. And in those cases, it may be that those represented are not necessarily even identified. The court will, however, look at whether there are any better placed challenges. If we go on to the second slide that came up in the Rwanda case, which I've dealt with in a previous webinar, so just to touch on briefly here, but the court said in relation to whether the charities and trade union had standing to pursue the generic complaints. So no, they did not. So Detention Action, Care for Calais, and the Public and Commercial Services Union, that was the civil servants who had to take the decisions in question. The court said the union's members weren't directly affected by the policy in any sense relevant for the purposes of seeking judicial review, and it couldn't be said that a person working for a public authority had sufficient interest to challenge a decision taken by that authority. The charities said they had surrogate standing because they represented the interests of those who were not well placed to bring an action themselves. But that was, the court said, undermined by the presence of the asylum seeker claimants who were better placed to bring the claim. The third slide as a reference from the judgment at paragraph 432. So the union's submission on standing amounts to the submission that any person working for a public authority has sufficient interest to challenge any decision taken by that public authority if she had some role in taking the decision. This would provide the union or any other trade union representing persons employed by a public authority a roving mandate to commence judicial review proceedings directed to any decision of which at least some of its members disapproved. And the submission was put in terms of the well-being of the union's members, but the substance of the matter was disagreement with the Home Secretary's policy. It wouldn't be uncommon for those who work in the public sector to disagree with one or more of their employer's policies. The stranger thing would be if no such disagreement existed. However, the union's members did not, by reason of their place of work or duties, have any greater standing than any other member of the public. And as their representative body, the union could be no better placed. We can move to the fourth slide to look at some further recent examples. The McCourt case, the challenge to the parole board's decision, the mother of a daughter murdered by the offender S in circumstances in which the parole board decided that S could be released. And S contended that the mother didn't have standing to challenge the parole board's decision. The permission for her underlying claim was actually refused, but the court said the following on standing. That sufficiency of interest would vary according to what the rule of law requires in the particular context of the challenge decision. It might not be possible to identify any class of persons more affected than the public at large. But in parole board cases, there was likely to be a small class of persons much more directly affected than the public at large, and that included the Secretary of State, the offender, certainly, not elected politicians, but it would include the victim or where they had died, their close relatives. So slide 5. we see what was decided. The claimant was directly affected by the decision to release S. Not only had he killed her daughter, that one issue before the board was whether his refusal to reveal the whereabouts of her remains was motivated by a desire to exert psychological control over the remaining family members. And so in those circumstances, it would be inappropriate to make the possibility of a challenge to the board's decision dependent on a decision of the Secretary of State to bring their own judicial review proceedings. The problem was that the decision of the Secretary of State as to whether to bring such a challenge would itself in principle be amenable to JR at the instance of a victim or relative, and the prospect of that sort of satellite litigation was unattractive. It could lead to undue complexity, and a release decision could be delayed or even quashed long after it had been given effect. So the better course was to recognise that in an appropriate case, a victim or relative would have standing to challenge the board's decision directly. Slide number 6. The court said that sentencing decisions in which the public interest was properly represented by the Crown, which we get from the Bolger decision, were distinguishable. That the role of the Crown in criminal proceedings and the Secretary of State in parole board proceedings was not the same. In the criminal proceedings, the public interest is properly represented by and channeled through the Crown, and that reflects the established role of the Crown in criminal proceedings as guardian of the public interest. The decisions in that role are taken independently of the executive, whereas the decision, such as the one under challenge in McCourt, was not part of the sentencing process, in which case the public interest was to be represented by the Crown. The position of the Secretary of State for Justice was quite different. They were performing their functions relating to parole board proceedings as a member of the executive. The court was satisfied that permitting victims or relatives to challenge parole board decisions was unlikely to burden it with a flood of judicial review challenges. The recently introduced right for victims or relatives to invite the Secretary of State to seek an independent review, and together with the requirement for permission to apply for judicial review, represented significant protection for the parole board. And permission was unlikely to be granted if the victim hadn't sought an independent review. Slide 7, moving on to one of the Good Law Project cases. This was about the procurement process for the award of contracts for the supply of PPE during the pandemic. The claimant sought JR of decisions by the Secretary of State to make direct awards of contracts for the supply of PPE to the interested parties pursuant to the public contracts regulations. And it was alleged that there was a breach of the EU principles of equal treatment and transparency by failing to put in place procedures that identify the selection criteria or evaluation guidance to be applied in deciding whether to contract with any supplier. It was also alleged that there was no fair competition between suppliers for any contract because the defendant had operated a high priority lane whereby suppliers who'd been referred by ministers, MPs and senior officials were afforded more favourable treatment, therefore significantly increasing their prospects of being awarded a contract or contracts. And it was also alleged that there was a lack of reasoning and irrationality. It was held that the operation of a high priority lane whereby suppliers of PPE who'd been referred by ministers or MPs and senior officials were afforded more favourable treatment was in breach of the obligation of equal treatment under the 2015 regulations and therefore unlawful. However, even if 2 such suppliers had not been allocated to the high priority lane, it was found that it was highly likely they would still have been awarded contracts because of the substantial volumes of PPE they could supply to meet an urgent need. Moving to slide number 8. So on standing, the claimants were held to have the necessary standing to bring a challenge based on breach of the principles of equal treatment and transparency or insufficient reasons for the awards brought under the regulations. And we note paragraph 502 in the judgment, it records that when granting permission, the judge expressly reserved the question of standing to be determined at the substantive hearing. And we see that the defendant had argued, paragraph 503, the claimants didn't have standing to bring their challenge under the ground of equal treatment and transparency or in relation to the reasoning under the 2015 regulations, but it was accepted by the defendant. They did have standing to bring the challenge in respect of the public law elements of the grounds. The court was satisfied, paragraph 505, that the claimants had sufficient interest to bring the challenge on each ground. And we see at slide 9 what the reasons for that were. So first, the Good Law Project is a not-for-profit company which aims to use the law to protect the interests of the public. It has a sincere interest, said the court, and some expertise in scrutinising government conduct in this area. 2, every doctor's interest in the challenge arose from its concerns regarding good governance and lawful procurement of PPE for the NHS. Thirdly, it's not realistic to expect economic operators to mount a challenge to the award of the contracts at issue in the proceedings, particularly in circumstances where there had been no competition and therefore no obviously identifiable disappointed bidders who might reasonably be in a position to identify causation and loss. And fourthly, the gravity of the alleged breaches concerning issues as to the lawfulness of the awards of public contracts supported a finding of standing so as to enable review by the courts. Slide 10, a further Good Law Project to claim this time against the Prime Minister about the making of appointments to senior positions critical to the government's response to the pandemic. The claimants sought JR of decisions taken by the defendant Prime Minister and Secretary of State to appoint 2 particular individuals, the chair of NHS Test and Trace and interim chair of the National Institute of Health Protection and the director of testing at NHS Test and Trace. And it was held that they not, as alleged, adopted a policy or practice whereby appointments had to be made without open competition, where only persons with some relevant personal or political connection to the decision maker or politician concerned could be appointed, and that positions had to be unremunerated. The claimants had also challenged an appointment on the ground of apparent bias. So the appointments didn't give rise to indirect discrimination on the basis of race or disability, contrary to the Equality Act 2010, but the Secretary of State had failed to comply with his public sector equality duty in making 2 of the decisions. At slide 11, on the general principles in relation to standing, the court noted that claimants such as NGOs had standing to bring claims even though they weren't directly affected by a decision. But in all such cases, the NGO concerned had a particular interest and in a sense was representative of an identifiable group in society which was affected by the decision or policy in question. In cases of individual employment, though, an individual could bring proceedings in an employment tribunal, and where no individual had done so, it was difficult to accept that a claim for JR could be brought by other individuals or an NGO. In relation to the indirect discrimination claim, neither of the claimants had standing to pursue those in circumstances where no individual complainant had come forward. So the claimants didn't have sufficient interest, and the employment tribunal would be far better suited to adjudicate on disputes of fact likely to be material to the outcome of any discrimination claim. Moving to slide number 12, case of AB and City Council. This was a renewal permission hearing. So did a teacher have standing to bring proceedings about the approach taken by a school to gender identity issues concerning a child? The claimant didn't teach the child in question, but sought to ventilate safeguarding concerns about them. And it was claimed by the teacher that they were acting in the public interest and as a whistleblower, relying on the Department for Education's guidance, Keeping Children Safe in Education, which states that all staff have a responsibility to provide a safe environment in which children could learn. Mrs. Justice Farby said on standing, not everyone with a personal interest in an issue would necessarily have standing, even if their beliefs or concerns were strongly held. There's a difference between a general duty on teachers to provide a safe environment and the right of any teacher to apply to court when she disagreed with the school's decision. And the claimant had no particular role in bringing public interest challenges. So if the mere assertion that she represented the public interest was sufficient to give her standing, the court would then have no way of distinguishing between a person with a genuinely sufficient interest and others. And delay was also a factor because time was critical in a case concerning educational provision for a young child, and the claimant had taken months to start proceeding against the school and hadn't brought proceedings even arguably promptly. Merits also were relevant. The formation and implementation of policies on gender issues in schools concerned complex issues of social policy, and it was a long-established principle of JR that in relation to such issues, raising multifactorial considerations for decision makers and these discretionary questions, the courts should be slow to intervene, and the court held that the claimant was using the banner of law in an attempt to persuade the court to enter into a policy debate that was ill-suited for judicial review. And so the grounds raised no arguable questions of public law. The last case, if we can move to slide 13, is Duff and Causeway Coast and Glensborough Council, Northern Irish case. The claimant's interest in planning permission granted for an infill dwelling was purely based upon environmental protection, and he was therefore found to have standing to bring judicial review, even though he'd not participated in the planning process. And the circumstances were found to be exceptional as follows. The local authority had conceded that the planning permission was unlawful and invited the claimant to issue proceedings so that he could quash the decision. He was the only challenger, and actually had been no objectors to the planning application, and the planning committee had granted permission despite the officer's recommendation that it be refused as it was in breach of several policies. That was part of the background as well. Leave had been refused initially on the grounds that the claimant had failed to participate in the planning process that led to the challenge decision, and because the environmental harm at stake was thought to be modest. And he also had another lead case challenging policy, which the court felt therefore militated against bringing myriad applications on the same point. Slide 14, the court said that the sufficient interest test should usually be determined at the leave stage, but could arise whenever a court was considering relief. The question of standing was a matter of jurisdiction to be considered carefully and in context. The court should avoid unnecessary costs and administration by not encouraging the proliferation of litigation by a busybody. So to have sufficient standing in the planning sphere, a litigant should ordinarily have participated in the planning process. There were exceptions to that, for example, where the litigant was misinformed or misled in some way about the planning process, and each case would have to be judged on its own facts, considering the context and what the interest was and the purpose of JR to correct public law wrongs. So ordinarily, the fact that Mr. Duff had not participated in the planning process would bar judicial review. However, although the court was reluctant to interfere with the standing decision, it held that the judge had not struck the correct balance between the competing interests. It was critical that the local authority had invited him to apply for a quashing order. If he was refused standing to challenge, then there would be no challenger to the impugned planning decision, and there was an overarching public interest in ensuring good administration and in correcting admitted public law wrongs. It was a rare case, but certainty wasn't undermined, and Mr. Duff had standing to proceed because of the local authority's actions in supporting him to apply. So the decision was highly fact-specific and not a charter for myriad judicial reviews to be brought in this area. There we are. Thank you very much for listening, and I hope that that will be a helpful roundup of some recent standing decisions.
Thank you. Well, I'll thank Kate from afar and note that it's certainly interesting following the various Good Law Project standing decisions that GLP seems to have stepped back from always participating in claims as a party. For example, the ongoing storm overflows case in which the Good Law Project is involved in supporting the three named claimants, but isn't itself a party to the litigation. Just a final reminder, any questions, email them through or put them in the Q&A for the end of the session. And we'll now move on to our final speaker, Brendan Brett. Brendan was called in 2017 and since joining Chambers has established himself as a public and administrative law junior, acting as both sole and junior counsel in both the High Court and the Court of Appeal. He has particular expertise in planning and environmental, judicial and statutory reviews, but has also advised and appeared in judicial reviews in other areas, including immigration and unlawful detention. Brendan will today be discussing the topic of expert evidence in judicial review, and so I will pass over to Brendan.
Good afternoon, everybody, and thanks for joining for this short webinar. I'm going to talk about expert evidence, and I'm going to share my screen if I can. It's been a while since I did one of these, so bear with me. Great. Expert evidence in judicial review, and I note we've got about 15 minutes left, so I'll try to get through it all, and if I don't, the references are on the slides that will be circulated around after the session, so please do follow up with those if I didn't get all the way through. So let's cover some of the basic principles in respect of both evidence generally and expert evidence in judicial review. Firstly, we know in judicial review that CPR 5416 provides that no written evidence may be relied on in judicial review unless it's filed and served in accordance with the rules or with express permission of the court. So, for example, we know the key moments at which evidence is normally fileable with the statement of facts and grounds for the claimant primarily, with the detailed grounds of resistance for the defendant. And one notes that there's not generally a right to file or indeed one is not generally expected to file evidence as a defendant with summary grounds of resistance, although practices do vary in that respect. The claimant may also, if there's a direction subsequent to the grant of permission, file evidence with a reply that's permitted, if that evidence is required to respond to something in the detailed grounds and the evidence filed with those. And then outside these areas, these normal areas, we need to file an application notice if we wish to rely on any additional evidence. Now, evidence other than the evidence of the decision under challenge in judicial review, i.e. in most cases the decision letter itself, is only admissible in judicial review in restricted circumstances. And the leading case on that is still the ex parte Powis case from 1981. And it sets out 4 particular circumstances in which evidence will be admissible. They're not exhaustive, but they're a pretty good indication of the sorts of things that the court will be looking for in evidence in judicial review. And essentially they're where the material was available to and considered ideally by the decision maker, or the evidence goes to a particular point of fact that relates to a legal ground that is pleaded in the judicial review proceedings. So, for example, a jurisdictional error, a procedural error, and I see I've repeated the pleaded issue as to whether proper procedure was followed. Clearly, it was a very important point in my mind when I was compiling the slides. And why is there a generally restrictive approach to evidence in judicial review? Well, it's as a matter of principle, that approach arises from the constitutional limitations placed on the courts when they are sitting in their judicial review jurisdiction. Their review is one of legality of the decision as taken, even if that concept of legality, error of law, is relatively expansively interpreted post Anasminic, rather than a review of merits. So in the vast majority of cases, evidence that postdates a decision is simply not going to be relevant to a question before the court. Turning then from those points about evidence generally to expert evidence in particular, we know that opinion evidence is not admissible by virtue of Section 3 of the Civil Evidence Act of 1972, unless it is expert evidence, i.e. evidence which is given 1, on a relevant matter, and 2, by a person who is qualified to give evidence on that matter. Now, it's clear from this definition, we don't really need to go any further, but it's clear that admissibility of expert evidence depends on these 2 factors. You must be able to show that your evidence is relevant to the pleaded grounds, that after all, that's always the test of admissibility of evidence, but also qualification of the person offering that evidence. And if one lacks either of them, the evidence is inadmissible. So, for example, in the RBS rights issue litigation case in 2015, a key question on that second point about qualification may well be whether or not there is a recognised body of expertise which is governed by recognised standards and rules of conduct, which is relevant for the question the court has to determine. Otherwise, the court ought to decline to admit evidence advanced by someone in the absence of such a recognised body of expertise, because that evidence will be the subjective opinion of the witness rather than an expert view arising from that body of expertise. So that may very well might be an issue. In terms of the rules, CPR 35.1 provides that the expert evidence in any case must be limited to that which is reasonably required to determine the claim. And it's worth pointing out that in CPR 35.4, you're always required to get permission of the court to rely on expert evidence. So even if we're putting in material with our statement of facts and grounds, so we don't require permission to put in factual evidence, we do require permission if we're going to put in expert evidence at that point. And then one of the leading cases on this question, the Law Society case in 2018, makes the short point that there is a very limited scope for expert evidence in judicial review, and the court will seldom, that's the word used, grant permission for that evidence. And why? Well, it's the same reason as the general approach to restrictiveness of evidence, the constitutional position of the court. So when might expert evidence be appropriate in judicial review? Well, the Law Society case gives us an indication, building on the Lynch and General Dental Council case from 2004. Expert evidence may be appropriate where the court requires the assistance or the explanation of various technical matters which the court needs to understand in order to understand the reasons given for a decision. So, for example, in Law Society, the court found that expert evidence could be admissible in judicial review where the impugned decision was challenged on the grounds that it was irrational because it had been reached by a process of reasoning which involved a serious technical error of a kind which, whilst not obvious to an untutored layperson, including the judge, could be demonstrated by a person with relevant technical expertise. And then importantly, and once explained, that error was incontrovertible. The upshot of that is, however, that if expert evidence was contradicted by a rational opinion expressed by another qualified expert, that technical error would not be incontrovertible, and therefore the expert evidence shouldn't be admitted. And why is that? Well, it's because it's a rationality case, and where there is a decision by a public body that evinces of more than one reasonable outcome or reasonable decision, the decision that was taken, if it falls within that bracket, will not be unpunable on rationality grounds. And so in that context, the expert evidence wouldn't be relevant. Importantly, and I'm on the bottom of this page now, the court explained in the Haringey case that it is not the function of any witness to a court to give their opinion on any matter of law or purport to answer any of the questions that the court itself is seized of determining in order to determine the claim. So when you have an expert witness, they shouldn't be giving any views as to, for example, how a particular piece of policy or statute should be interpreted. They should not give an expert opinion or any opinion about whether or not a particular factual scenario which is at issue in the proceedings is more probable or less probable, nor if we're in a human rights case, should an expert give any opinion as to whether a particular interference with convention rights is proportionate or disproportionate. So now into some of our cases that I want to gander through quickly, and you're going to have some nasty flashbacks, I'm sure, of some of the pictures on these slides. I've tried to keep them interesting. The first case I'd like to mention is another Good Law Project case. This one in the Technology Construction Court, and related to the procurement by the government of services from a company, Hanbury, for policy development during the pandemic. And the claimant in that case advanced 4 grounds, which will be relatively familiar from some of the other Good Law Project cases that Kate has spoken about earlier. Ground 1, lack of transparency. Ground 2, apparent bias due to the relationship between Hanbury and Mr. Cummings, pictured. Ground 3, breach of the public contract regulations in 2015, and ground 4, a sort of catch-all disproportionate argument. In this case, there was a dispute as to the admissibility of parts of the claimant's evidence, and the judge, Fraser J, if I remember properly, set out some of the principles that I've summarised helpfully at paragraphs 19 to 24 of the judgment. Interestingly, in that case, the evidence in question was about polling. One of the arguments being made was that one of the disputes between the parties seemed to be how excellent Hanbury was at some of the things that the government wanted them to do. And that included gauging public opinion. And in that case, that expert evidence was ruled inadmissible for 3 reasons. 1, there was no recognised body of expertise. Remember the rights litigation dicta I showed you on the previous slide. No recognised body of expertise governed by recognised standards relevant to the field of polling. 2, the judge didn't consider that really the question of how good Hanbury was at polling was relevant to the grounds of challenge. And even if it was, 3, it wasn't reasonably necessary to determine the questions for the court. So for those reasons, the court refused to find that evidence admissible. As a pleasant dicta that the court would not be assisted by Mr. Cummings saying that Hanbury was the best in the world, and Mr. Moon saying no, it was not. That's not the kind of dispute that the court wants to have in evidence. And then there are some interesting comments in that case also, and I'm conscious of the time, about what isn't expert evidence to fall within some of the principles that we discussed earlier. So, for example, it's not expert evidence if someone within a particular trade wants to inform the court as part of their factual evidence what the customary meaning of a particular term is when used in that trade. Or, for example, mere comment. Now, we all find, or I certainly find, that a lot of time witness statements do make comment about the case or other evidence in the case. Fraser J said, well, that's not expert evidence, it's merely comment. And whilst that shouldn't be in the witness statement, it's not going to be a proportionate use of the court's resources, and parties shouldn't be encouraged to pursue a line-by-line analysis of a witness statement, striking out all the bits of comment and leaving all the bits of fact in. That's not going to be useful use of the court's resources. Let me quickly talk about this case, and then I think that will be it. This is another Good Law Project case. This is the rapid flow test case. And I raise it because it reiterates some of the points that I think we must all be very aware of but also remind ourselves of the importance of procedural rigor in judicial review and public law proceedings. We don't get any special ticket because we're raising matters of or dealing with matters of public importance, and there must be compliance with the rules. And in this case, there must be compliance with Part 35 in respect of experts' evidence. In that case, the Secretary of State sought to rely on a witness, an expert report from an expert on state aid in this case. And on the third attempt, they still hadn't managed to get their expert report correct. And on that basis alone, the judge refused permission to rely on it. And the judge in that case reiterated those important dicta from the Queen on the application of AB against Chief Constable of Hampshire, that the conduct of litigation in accordance with rules is a fundamental part of the overriding objective, and public law proceedings don't fall into an exceptional category there, and that applies to expert evidence as well. So non-compliance will result in a ruling inadmissibility. I'm going to have to call it off then, because I noticed we're already past 2 o'clock. Please do read the slides, the rest of the slides I prepared. They don't have massive amounts of detail in, but they'll give you the reference to the case and a couple of pointers, and hopefully that will enable you to keep up to date on all the latest hot topics on expert evidence in judicial review. So with that, I'll pass back to Flora, saying thank you very much for listening.
Thank you, Brendan. Yes, it's past 2 now, and I see we don't have any questions in the Q&A, so we'll wrap up there. Thank you to our 3 speakers and to all of you who've attended today's session. The Public Law webinar series is taking a summer holiday, but will return in autumn with 2 seminars on the public sector equality duty and an update on legislation. So look out for emails to sign up to those, and thank you all for attending.